Hi guys, today is the 10th of November and we're going to present to you the video, the much anticipated video about MediClinic, and then we're also just going to touch on Sanlam because they've been very, very naughty.
Yeah, Leonie, let's deal with the issue of MediClinic. And this has now been coming up for the last 2 weeks. We've warned MediClinic, we've spoken nicely, we threatened, maybe, if you want to see these threats. But somehow MediClinic just blunders on. I don't know what's going on in that company. I don't know why people do not listen to good advice. I don't know if it's the consultants, the lawyers giving them poor and bad advice. But these guys are just really messing it up. And during the past week, we received quite a few complaints now that by Friday this week, all the initial processes needs to be finalized now. The so-called exemption process from the much vaunted policy of MediClinic. Because MediClinic still believe themselves to be above law and above the constitution and above human rights in South Africa. And therefore still their workers must now present applications for exemption that will come before a board of doctors and arbitrators. Oh guys, just get real. Just get real in life. Okay, in this we had the fortunate incident of where we received the recording of a human rights manager inside MediClinic that unfortunately for him and for MediClinic just could not stop, and he ran his mouth as to the end game of what is going to happen after February next year in MediClinic. So here goes what this guy had to say. He says that the process will go on, and those people that will not be exempted in this much vaunted process of theirs, high-powered process, those poor souls, and there's about 10,000, 20,000 of them still left in MediClinic, because remember, out of 33,000 employees in MediClinic, only 9,000 vaccinated. But thousands upon thousands of MediClinic's employees will face dismissal if they are not exempted from this policy. And then he makes the crucial mistake. He tells us the end game. And he tells us the end game is that they will follow an incapacity process in the workplace. Now guys, let's go delve a little bit into labor law, because we need to understand these things. When you go back into the videos, many months that I've been telling people what to do and not to do, explaining labor law in South Africa, you can go and you can listen to all my videos. There's a constant message coming through, and that constant message is a simple one. We do not have a legal framework in South Africa in our labor law to dismiss employees for not vaccinating. Right? We don't have it. So let's start off again, because it seems to me the people at MediClinic needs to hear this again. So apologies to all the other people in South Africa that by now clicked and actually do understand what it's about. First off, a retrenchment process can never be followed. The Section 189 process can never be followed in this scenario, for the very simple reason, if you look at what operational requirements of a business is, crystallized in law, crystallized in legal precedent in labor court and labor appeals court, you will find that vaccinating workers in a workplace does not even come close. Secondly, if you look at what Section 189 prescribes, it's prescriptive. It says, employer, you must do this, and if you don't do it, then it becomes unfair. You must look at things like, for instance, measures to avoid dismissals, measures to minimize dismissal, measures to counter adverse effects of dismissal, and then most importantly, fair criteria. And those fair criteria has also been crystallized in law in South Africa, because we deal with law decades old. Retrenchment is simply not there as a procedure that can be followed. MediClinic, and you know it, and I know it, and everybody else knows it by now, you can't use retrenchment. And then, of course, you sit with another problem relating to retrenchment, and that is the cost of retrenchment. Now, what do I mean by cost of retrenchment? Because I'm very sure your lawyers did not discuss this with you. It costs a huge amount of money for a company to dismiss. And it costs a huge amount of money, even more so, to dismiss through operational requirements. Why? Because you have to pay out the following to the people being retrenched. You must pay out all outstanding leave to those employees. You must pay out notice in terms of the Basic Conditions of Employment Act. Then you must also pay out the years of service. And that is calculated on their last gross salary. And the people that you would have intended to retrench are highly paid individuals. We're speaking of people, salary packages 30, 50, 80 thousand rand a month, huge earners. MediClinic, as simple as this: if you retrench 10,000 people out of your ranks, you bankrupt. Shareholders of MediClinic, listen to what Skalk van der Merwe is saying to you tonight. Pull your money out of MediClinic now, because if they retrench, it's going to cost them so much money that for a couple of years down the line, you will not receive dividends. There will not be profits in that company. How do I know this? Because I have facilitated literally hundreds of Section 189 procedures, hundreds of retrenchments. So I know how to calculate costs. And I know how much it's going to cost you. I did the calculation already. I'm not going to tell you how much. I leave that with you. We're speaking of millions upon millions of rands that retrenchment will cost you. So forget about retrenchment. Not going to happen. Second option, and here I'm going to refer you now directly to law. I'm going to read to you out of the law itself. The Labour Relations Act, you already know about that. I told you about that in previous videos. I'm not going to repeat myself. You must listen in class. You must listen in class. I'm not going to repeat. But there's a schedule to that act. And that schedule tells you how do you effect dismissals in the workplace. A step-by-step handbook or manual for you to go and read to make it possible for you to comply with law so that you do not end up in Labour Court or at CCMA and have to pay huge amounts of compensation. When the people drew up these legislations, they knew the employer will suffer. It would be difficult for them to comply, and therefore they wrote schedules, manuals of how to do these things. And you will find this in Schedule 8 to the Labour Relations Act. I'm going to show it to you. I hope the camera can catch it.
No, not really. There we go.
There we go.
A little bit.
Actual legislation, the Code of Good Practice Dismissal, Schedule 8 to the Labour Relations Act. That is the manual that tells you how to dismiss. You don't have to go and consult somebody. You can go and read it yourself. It's plain English. It's written as simply as possible so that you as employer can read it for yourself. Fair reason for dismissal. Item 2. It says the following. Whether or not the procedure is fair is determined by referring to the guidelines set out below. And then it goes to say the Act recognizes three grounds in which a termination of employment might be legitimate. Right. It says conduct of an employee, the capacity of the employee, or operational requirements. That's Section 189 that I just discussed. Forget Section 189, not applicable anymore. What you're left with, conduct, that is misconduct. That is where you charge an employee for misconduct in the workplace through a disciplinary inquiry, and he's then dismissed for misconduct. Now, we can forget about charging an employee for not taking a vaccine for the very simple reason he is exercising his constitutional rights by not taking it. Now, if you dismiss a person because he's standing on his constitutional rights, it's what's called an automatically unfair dismissal, for which you can pay 24 months compensation. So forget about conduct. So all that is left is what this human resources official had to say. And that comes down to capacity. Now let's go to capacity in the Act. And I'm going to read it to you. It's there.
Talking about spoon feeding, eh?
I'm actually now reading law to you. Because apparently your lawyers and your consultants didn't read the law to you. Didn't tell you what's in the law itself. And you can find this in item 8, incapacity, poor work performance. Now I'm going to read it to you. It says a newly hired employee may be placed on probation for a period that is reasonable. It goes about probation. We don't deal with probation here, so obviously that's not applicable. Then it goes further to say, guidelines in cases of dismissal for poor work performance. Any person determining whether the dismissal for poor work performance is unfair should consider whether or not the employee failed to meet a performance standard. He doesn't want to vaccinate. It's not a performance standard. Then it goes further to say, and if the employee did not meet a required performance standard, whether or not the employee was aware or could reasonably be expected to be aware of that required performance standard. Then it goes further to say the employee was given a fair opportunity to meet the required performance standard. And lastly, dismissal as an appropriate sanction for not meeting the required performance standard can be effected. Capacity deals with a performance standard, not with vaccination. So HR official running your mouth, threatening an employee to go and vax because you will be fired for incapacity in your workplace, you did not realize that you were speaking about a performance standard. There's no performance standard if a person is vaxxed or unvaxxed. So obviously this is not appropriate. But then it goes further. Item 10, very clear. It says incapacity, ill health or injury. Now remember, now we're dealing with another section here where a person becomes ill or there's an injury that causes him not to meet the standard. And it describes very clearly to you temporary or permanent or whatever injury or illness that causes a person not to be able to perform his duty. We're dealing with ill capacity based on a person not being able to perform because of illness or injury. The people unvaxxed are not sick. They have not been sick the last 2 years. They've been working throughout the last two years under the safety protocols as published. They are not sick. They're not ill. They are not injured. They are meeting their performance standards. You cannot dismiss them for ill capacity. It is not applicable. It is not relevant. Okay? It's as simple as that. It goes further to say that if a person is injured in the workplace, vax injury maybe, then there's an additional duty on you to ensure that that person must be placed or accommodated so that he does not lose his work, or he must be compensated for that injury. Now you have a problem. And then lastly, guidelines in cases of dismissal arising from ill health or injury. Any person determining whether the dismissal arising from ill health or injury is unfair should consider whether or not an employee is capable of performing the work, and if the employee is not capable, the extent to which the employee is able to perform the work, the extent to which the employee's work circumstances might be adapted to accommodate disability, or where it is possible, the extent to which the employee's duties might be adapted, and lastly, the availability of a suitable alternative work. Now you, MediClinic, you tell me tonight, how the hell do you intend dismissing unvaxxed employees by invoking ill capacity? You tell me. I've laid down the law now for you. Can you see how you are making a fool of yourself in front of the entire South Africa? Do you realize how stupid you look? How dumb you look in the eyes of your employees who did go and study those things because I sent it to them previously? That is why they are challenging you left, right, and center, because they know your end game is a failed game. Let's deal with Sanlam. Sanlam, running like a little dog behind MediClinic, also putting pressure, also hoping on this end game that I've just explained cannot work. Stop your nonsense and stop it now. Everybody is seeing what you're busy with. Stop it. There will be consequences. There will be legal consequences in your workplace if it means that it fails you as a company, it brings you down as a company. That is not on me. That is on you, Mr. Director of Sanlam and of MediClinic. You have been warned now, not once, several times. You've even been told the law. You've been read the law.
Spoon-fed.
Spoon-fed the law. And you still run around like clowns. What the hell is wrong with you guys? And that is all I want to say. Leonie, maybe something from you.
Well, Scott, no, I just want to mention as well, where Sanlam is hiring, no, not hiring, what's its name? Okay, Scott, I also just want to mention about, for instance, Sanlam renting out offices within their building, and then they don't want to give people access to the building unless they're vaccinated. You're not allowed to do that. You can't do that.
Yeah, we covered that in a previous video also. There's a lease document signed by both parties. If the person renting from you is not in contravention of that lease agreement, he is within the law. You can do nothing against him. Nothing. You can't threaten him. You can't coerce him. You can't go on like a mad dog. You can't chase him out of his own building. He's renting. That space that he is paying for is his until the end of that lease. I hope I'm clear, crystal clear tonight.
And again, no one is above the law. Not you, MediClinic, and not you, Sanlam, either. So, I would suggest that you start following the law. Otherwise, we won't get off your case. You can be sure of that.
Thank you so much, Leonie. I think let's end this off. The message now is crystal clear. My hand is still out there for you. My help is still there for you. But if you go on with what you're going on, there will be retribution. And it's going to be legal, and it's going to cause you a lot of costs and a lot of pain. Believe me that. Thank you.
And also, MediClinic, good luck with your patients trusting you now. Just saying.